Hello everyone, and welcome to your very first lesson of the Legal English course in C1. Well, you're quite the experienced person. That's impressive, so I'm hoping I'm going to be able to provide you some useful information in here. And the first lesson is an expert legal drafting style. What exactly are you going to learn today? How to master precision and authority in legal drafting at C1 level, 12 key vocabulary words with phonetics, some grammar, inversion for emphasis, nominalization in complex noun phrases, drafting canons, and how to apply the major canons of construction to draft and interpret legal documents. And на правах реклами можу вам сказати, що ви можете знайти цей воркшіт і набагато більше іншого корисного нашого контенту в телеграм-каналі і інших соцмережах 10 Instance. Також перед вами зараз є QR-кодик з нашим телеграм-каналом, який ви можете відсканувати і потрапити до нього. Так? Well, let's go. You're going to have quite a lot of words today and quite difficult ones, so I believe in you. Drafting canon. And by the way, if I'm talking too fast for you, if I'm reading too fast, you can slow down the video or you can pause the video and look at these words and read them again, read the meaning, read the example. So take your time. And let's go. Drafting canon. What exactly is a drafting canon? That's an established principle used to interpret the meaning of legal language. For example, the contra preferentum canon means ambiguous terms are read against the drafter. Wisdom generis, it's where general words follow specific ones. The general words are limited to the same category. Cars, vans, lorries, and other vehicles. Wisdom generis. Wisdom generis limits other vehicles to road vehicles. Nasera associates. A word is known by the company it keeps. Meaning is drawn from surrounding words. Nasera associates maintenance. In a list of financial obligations will take on a financial meaning. Expressio unis. The express mention of one thing implies the exclusion of others. Expressio unis. A list says France, Germany, and Spain. Italy is excluded by the implication. Contra preferentum. That's an ambiguous term. Those are ambiguous terms that are constructed against the party that drafted them. For example, contra preferentum is the drafter's greatest adversary and the clearest argument for precision. Construe. To interpret the meaning of legal document or provision, the court construe the clause in favor of the claimant. Purposive. Purposive. An approach to interpretation that focuses on the purpose or intent behind a provision. A purposive reading of the clause gives effect to what the parties actually intended. Literal rule. Interpreting words according to their plain, ordinary meaning. The literal rule. If the words are clear, apply them as written, even if the result seems harsh. Golden rule. Modifying the literal meaning only to avoid the absurd result. Under the golden rule, an absurd or repugnant literal reading may be corrected. Mischief rule. Interpreting provision in light of the problem it was designed to remedy. The mischief rule asks, what was the legislature trying to fix? Canon of construction. A principle or rule that courts apply when interpreting a legal document. Knowing the canons of construction helps drafters avoid ambiguity before it reaches court. And repugnant. In legal drafting, contradictory or inconsistent with another provision. A clause that is repugnant to the main agreement may be struck out by a court. And a little pro tip, the best legal drafters know how courts will read their words. Before finalizing any clause, ask yourself, how would a judge apply the iusdem generis? Iusdem generis. How would a judge apply the iusdem generis, expressio unis, and contra preferendum canons to this? If the answer makes you uncomfortable, redraft until it doesn't. Let's go to some grammar, inversion, complex noun phrases, and drafting canons in practice. So, inversion in legal English writing, we use it for emphasis in opinions, arguments, and legal memos. Rarely does a single ambiguous word generate so much litigation. Not only does the clause fail to define the term, but it also contradicts clause 8. Only by reading the contract as a whole can the true intention of the parties be discerned. So, as you can see, it is a little bit barbaric for me to say that as an English teacher, but basically, inversion that is a question word order, but without a question mark in the end of the sentence. Okay? Rarely does a single ambiguous word generate. Not only does the clause fail to define, only by reading the contract as a whole can the true intention of the parties be discerned. Complex noun phrases. Why are we using it? We use it to pack information into precise noun groups instead of writing a extremely long sentence. Yeah? The failure of the drafter to anticipate the iusdem generis risk. The court's purpose of construction of the termination clause. The implied exclusion arising from the expressio unius principle. And applying drafting canons in practice. Iusdem generis. If you want other acts to be truly open, add of any kind or without limitation. Expressio unius. If a list is meant to be open, signal it, including without limitation. Nocere suis. Nocere suis. Nocere suis. Place words in the context that give them the right meaning. Contra preferentum. If you drafted it, ambiguity works against you. Be precise. Here is a little model legal opinion paragraph. Read and analyze. The question turns on the proper construction of clause 9.2. Not only is the provision ambiguous on its face, but it also sits in tension with the definitions clause, which expressly limits the term losses to direct damages. Applying the nocere suis canon, the word consequential in clause 9.2 must be read in the context of the surrounding loss categories, all of which are direct in nature. Rarely has a more obvious case for the application of the iusdem generis principle presented itself. Furthermore, should the court decline to adopt a purposive approach, the contra preferentum rule would require that the ambiguity be resolved against the defendant who drafted the clause. In our view, the correct construction is that clause 9.2 excludes only direct consequential losses as the term is understood in the context of the agreement as a whole. Let's notice some things. Not only is the provision ambiguous, but it also sits in tension. That's an inversion for emphasis. Rarely has a more obvious case presented itself. That's a formal inversion once again. Three canons applied in sequence. Nocere suis iusdem generis contra preferentum. Complex noun phrases throughout. The proper construction of clause 9.2, the surrounding loss categories, and purposive approach acknowledged as an alternative route to the same conclusion. Here you have some common mistakes to avoid. Iusdem generis means general words include everything. Iusdem generis limits general words to the same category as the specific words that precede them. The canon restricts, not expands. The court construed the clause literally, so it was fair. The literal rule may produce harsh results. The golden rule allows deviation to avoid absurdity. Literal doesn't mean fair. Courts have options. Rarely the court has found. Rarely has the court found. That's an inversion. So in inversion, auxiliary verb will be before subject. As I told you, the question word order. The clause is repugnant without context. The clause is repugnant to or inconsistent with clause 4. Repugnant always means inconsistent with something specific. I think the purpose of this clause is a purposive construction of this clause suggests that it is better to use some formal structures instead of just I think. Yep. And what do I need to do in here? I'm going to give you 20 seconds. Pause the video and match each canon to its correct application. And we're going to check it down below, okay? I want to expand it a bit to make it a bit more aesthetic. I'm giving you 20 seconds starting now. Take your time. I cannot expand it, I'm sorry. Yeah. No, I cannot expand it. Well, let's go, let's check it. The first one is going to be B. Use them to nearest cars, and other vehicles limited to road transport. The second, special units, ambiguous list in France and Germany implies Italy is excluded. C. The third one is going to be D and number 4A. So check it out. 1B, 2C, 3D, and 4A. And for the last part, speaking challenge, canon analysis. So read the following clause and identify which drafting canons apply. Then explain how a court might construe it. The supplier shall not be liable for any loss, damage, cost, claim, or expense arising from fire, flood, earthquake, or other natural event. Canon that applies something. How a court might construe other natural event something. How would you redraft to make the clause open to all force majeure events? And the question for you for the comments, which drafting canon do you think causes the most problems in real contracts? Could you give example from your experience, or you can imagine one, you can make up one, and could you explain how would you draft around it? And for workbook, I'm not going to show you any tasks. I am such a person. I cannot show you any tasks. So you can find those in our Telegram channel. Yep, you can Google this routine stance, or you can scan this QR code and get in there. Okay? Well, thank you so much, guys, for coming in here. I was so happy to see you. I was so happy to talk to you, and I hope to see you next time. See ya. Bye bye.